Things had been rather quiet this week in the saga, and I knew that meant something was cooking. And it is done. It actually boiled over. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. I've been waiting for this one, and it's finally here. The Van Zan of it all, front and center again. Many of you remember Van Zan, right? That is the company associated with Malice in Wonderland and her husband, Van Zan. That's the company that filed a lawsuit, a Doe lawsuit against Baldoni and the Wayfarer defendants, although they were not named. I still don't understand how Van Zan can file a lawsuit for breach of contract against people that Van Zan had no contracts with. However, the real reason for the Van Zan sham of it all was so that the docket duchess could legally be in possession of all of Jen Abel's texts and emails. Jen Abel is Justin Baldoni's longtime publicist. She works for her own company now, but when this saga first began, she used to work for Stephanie Jones at JonesWorks. Stephanie Jones fired Jen Abel when she got word that Jen was going to leave to start her own company, and she, according to Jen Abel, illegally took possession of her personal phone as well as her laptop and all of her emails and even health information. And a while ago now, Van Zan was ordered to give information to the Wayfarer parties. But things have hit a road bump. According to a just-filed motion to compel, the zero-time Oscar-nominated actress and her husband are refusing to cooperate with the Van Zan of it all. Kevin Fritz, one of the lawyers for Baldoni and Jen Abel and the Wayfarer parties, just told Judge Lyman, who is seeing this other related litigation with Stephanie Jones versus them. And Stephanie Jones is also suing some Doe people for all those websites against her. What a mess. What a mess. A lawyer for the Wayfarer parties says, "Dear Judge Lyman," my former bestie, her current bestie, "in connection with a deposition set for September 30th, 2025, defendants Jennifer Abel, Melissa Nathan, Justin Baldoni, and Wayfarer Studios, LLC, collectively the Wayfarer parties, move pursuant to Rules 1C and 4C of Your Honor's Individual Practices and Rule 45 of the Federal Rules of Civil Procedure for an order compelling non-party Van Zan, Inc." And if you don't know, Ryan Reynolds is from Vancouver, Canada. Specifically, this motion to compel Van Zan is to force them to designate a witness, they say, prepared to testify about the full period of its relationship with plaintiffs Stephanie Jones and JonesWorks, LLC, collectively the Jones parties. As set forth herein, Van Zan is attempting to curtail its testimony to omit information the court has already declared is relevant. What are you two trying to hide? Rule 26 provides that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering, among other things, the party's relative access to relevant information, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. The Federal Rule of Civil Procedure 26b1, Rule 26 further provides that information within this scope of discovery need not be admissible in evidence to be discoverable. And honey, the Van Zandt of it all is very relevant, I say. We know. The motion to compel continues, saying, the party seeking discovery bears the initial burden of proving the discovery is relevant. Once that party has shown relevance, it is up to the responding party, Van Zandt, to justify curtailing discovery. Ms. Abel's counterclaims allege that in August 2024, just prior to her scheduled departure from Jones Works, the Jones parties seized her cellular phone, accessed the contents, and downloaded them. The counterclaims further allege that Stephanie Jones disclosed at least some of Miss Abel's private communications to the Lively parties no later than August 21st, 2024. Remember, the Van Zandt of it all, that sham subpoena, was not created until September of 2024. The oxygen inhaler knew, most likely in September or before, that she was planning to sue, or at least threatening to sue, Baldoni and the Wayfarer defendants. But while she had some of Jen Abel's communications, according to them, thanks to Stephanie Jones, they claim, she needed much more and a legal reason to be in possession of them. Because the New York Times would not have printed all of this if the second wife of Ryan Reynolds had not proven to them that she was in legal possession of all of these materials. And today's motion to compel adds that after that date of the 21st of August, Stephanie Jones continued to access Miss Abel's private text messages thereafter, and at some point transmitted Miss Abel's stolen communications to Miss Lively, her husband Ryan Reynolds, and Leslie Sloan, Miss Lively's publicist, to harm Miss Abel. Miss Abel also alleges that Miss Lively conspired with the Jones parties to obtain Miss Abel's stolen data under the guise of legal process. On September 27th, 2024, Miss Lively used her company, Van Zandt, to file a lawsuit in the New York State Supreme Court against Doe defendants, the Van Zandt lawsuit. The complaint in the Van Zandt lawsuit alleges that the Doe defendants, the identities of whom are unknown to Van Zandt, breached unspecified obligations via unspecified oral promises and or unspecified written agreements. Days after the Van Zandt lawsuit was commenced, Van Zandt issued a subpoena therein to the Jones parties demanding the production of documents pertaining to the film It Ends With Us, Miss Lively, Mr. Reynolds, and sexual harassment and retaliation in connection with the production of the film, none of which are even remotely referred to in the complaint filed in the Van Zandt lawsuit. Because that lawsuit was a sham. The Jones parties then handed over Miss Abel's communications to Van Zandt. Subsequently, the Van Zandt lawsuit was discontinued in December 2024. The same month, Miss Lively included those communications in her pleadings. The tea is piping hot, even though some of us know all of this. The fact that it is bubbling up again and boiling over, it is tickling me in all of the best ways. In late June 2025, Ms. Abel filed a motion to compel Van Zandt to produce certain documents in response to a subpoena, which I told you all about. In a memorandum and order dated July 7th, 2025, the court properly determined that communications between Van Zandt and or its counsel and the Jones parties and or their counsel concerning the Van Zandt lawsuit are relevant. Specifically, the court noted that the statutes under which Miss Abel brings her claims prohibit both obtaining and disclosing protected information. The court correctly stated, quote, communications between Van Zandt and or its counsel and Jones Works and or their counsel concerning the Van Zandt lawsuit are likely to bear on or lead to further information regarding whether and when Jones obtained relevant communications and disclosed them to Van Zandt or Lively. The Wayfarer Party's deposition subpoena, as amended, the subpoena commands Van Zandt to produce a witness who can testify about the enumerated topics, including the ownership and management of Van Zandt's communications with the Jones parties, the subpoena issued in the Van Zandt lawsuit, communications with Miss Lively related to that subpoena, and Van Zandt's search for relevant documents. To the extent that topics number 4 and 5 could be construed as overly broad, the Wayfarer parties have agreed to narrow topic number 4 to Jennifer Abel's counterclaims in this action and the defenses thereto, and narrow topic number 5 to Blake Lively's allegation in paragraph 10 of her second amended complaint that she obtained the communications cited in her pleadings in connection with a lawful subpoena. Nonetheless, Van Zandt is refusing to provide a witness who can testify at a deposition about such communications and the related topics. According to its written objections to the subpoena, Van Zandt will only provide information for each of the topics starting from on or about the filing date of the Van Zandt lawsuit, which is September 27th, 2024. Okay, why? Obviously, things happened in August, as we mentioned, that are also relevant. Why are you going to start? It's not up to you, babes. Ugh. Lawyers be lawyering. Subject to that unreasonable limitation, Van Zandt stated that it would designate a Rule 30b-6 witness reasonably prepared to testify about non-privileged information response to these topics. Stated differently, Van Zandt only agrees to produce a witness to testify about what happened after, like I said, the Van Zandt lawsuit was commenced, but not before it was filed. Very shady. Super sus. Even though the communications between Van Zandt and the Jones parties or their respective representatives concerning the contents of Jennifer Abel's electronic data seized by the Jones parties and subsequently delivered to Blake Lively through Van Zandt is highly relevant to Miss Abel's counterclaims against the Jones parties, and even though such communications surely occurred before the Van Zandt lawsuit was filed on September 27th, they put the wrong date. They said 2025. Anyways, we know what they meant. Van Zandt is refusing to designate a witness prepared to testify about the foregoing. Van Zandt argues that the information sought is obtainable from other sources? Who? I mean, maybe they could argue that Stephanie Jones should have all of that. Okay. All right. I could see that. But being deposed is different from handing over things in a subpoena. I need the lawyers here to chime in. Does this objection of, we're not going to talk about it before we file the law, that doesn't seem rational or sensible. I would understand withholding documents that they feel are duplicative, because I argued that myself against Blondie. But if I was deposed, I wouldn't say, I can't talk about anything before the lawsuits were filed. However, their motion to compel continues. As the court stated in its memorandum and order, there is no per se rule that party sources must be exhausted before documents are subpoenaed from third parties. Putting aside that no other witness has testified about most of the topics, even if such cumulative testimony existed, the Wayfarer parties are entitled to test what witnesses to the same events have to say and whether they contradict or corroborate each other. They quoted the law. Seems sensible. There is no undue burden imposed upon Van Zandt. The corporation has known for months, and certainly since June 2025, when Ms. Abel moved to compel its compliance with a document subpoena, that it was in possession of information material and relevant to the claims and defenses herein. Furthermore, given the allegations in the counterclaims, the relevant period is not expansive. Although the subpoena defines the relevant time period as January 1st, 2022 to the present, the Wayfarer parties agree to limit the relevant time period to July 1st, 2024 through December 31st, 2024. 6 months or so? Very reasonable, I think. The subpoena was initially issued on September 9th, 2025, and noticed the deposition for September 29th, 2025, which was later adjourned to September 30th, 2025, next week. A period of 20 days for compliance, which is more than the 14 days that courts in this circuit have found to be presumptively reasonable. Therefore, they wrap up saying, the Wayfarer parties respectfully request that the court issue an order compelling Van Zandt to designate a witness prepared to testify at deposition about the full extent of the relationship between Van Zandt and the Jones parties, including the period before the Van Zandt lawsuit was filed. In the event the court grants this application after Van Zandt's deposition commences on September 30th, 2025, the Wayfarer parties respectfully request that the court direct Van Zandt to designate an appropriate witness to appear for a deposition consistent with the court's ruling concerning the topics during the first 2 weeks of October 2025. Respectfully submitted, Kevin Fritz. But we're not done, because there's some juicy morsels in the other filings that were attached to this. According to K. Fritz's declaration in support of the motion to compel, quote, according to a biennial statement filed with the New York State Department of State Division of Corporations on June 30th, 2025, the chief executive officer of Van Zandt is Ryan Reynolds. Additionally, this is interesting. According to the docket from the Van Zandt lawsuit, a true copy of which is attached as Exhibit F, Van Zandt did not file a request for judicial intervention, and no judge was assigned to the case. Translation: sham subpoena, sham lawsuit, we know why. Interestingly here, in a footnote, it says, the Wayfarer parties are not seeking to compel the production of documents. I wonder why that is. Maybe that's just a separate thing, right? I don't, that's interesting. Literally, it says, on September 9th, 2025, the Wayfarer parties issued the subpoena to Van Zandt, which commanded a representative of Van Zandt to appear for a deposition on September 29th, 2025, which has been changed now to the 30th, and the production of documents. But footnote number 3 says the Wayfarer parties are not seeking to compel the... Okay, I get it. Well, I don't get it. I'm confused. Maybe they have enough documents and what they're focused on is just getting something on the record, like trying to catch them in a lie. And that might be why they're resisting, because they know they did some shady and they don't want to incriminate themselves or anybody else. I don't know. I'm in my Elle Woods era, but not a real lawyer. If you are, would love to hear your thoughts on this. Specifically, according to the declaration, the topics that they want to cover in the deposition of the Van Zandt witness are Lively's direct or indirect ownership interest, the ownership interests in Van Zandt, its managerial structure, the parties' claims, allegations, defenses, and counterclaims in this action, the parties' claims, allegations, defenses, and counterclaims in the action Lively versus Wayfarer Studios, Van Zandt's relationship and communications with Jones, Van Zandt's relationship and communications with Jones Works, the issuance of and communications relating to the subpoena. All seems very sensible so far. The claims and allegations in Van Zandt Inc., the Van Zandt lawsuit, your communications with Lively relating to the subpoena, and your document collection, document search, and document production in this action. This is why they were so quiet, going back to what I said earlier. On September 22nd, 2025, I met and conferred telephonically with Van Zandt's counsel about its objections to the subpoena, including the topics on which the Wayfarer parties seek deposition testimony. Van Zandt's counsel claimed that the testimony sought could be obtained from a party. When I asked Van Zandt's counsel to specify which party, Van Zandt's attorney, John Federloff, stated that his understanding was that Blake Lively testified about the topics. In response, I asked Van Zandt's counsel if they possess a copy of Miss Lively's deposition transcript, which has been designated confidential under the protective order. Van Zandt's other attorney on the call, Margarita O'Donnell, answered, "We're not answering that," or similar words to that effect. If they can catch them breaking the protective order, that is a real bad look for the former power couple. Now, well, he's still a power A-lister, but F, D minus. She got that Lionsgate movie in the works. Oh my God, I am so glad I read this declaration because there is so much here. Fritzy says Miss Lively did not testify about Van Zandt except for one sentence. So is Van Zandt now saying that she's going to be their witness next week? I would love that. They're not saying that. They're not designating a witness yet. But hopefully Judge Lyman does the right thing and compels. Yesterday, the declaration says, Van Zandt served its objections and responses to the subpoena. Why did they wait so long? In the objections, Van Zandt objected to all the topics, alleging that the testimony sought is irrelevant to the claims, defenses, facts, or circumstances related to this action. ¿Qué? Jen Abel, Stephanie Jones, New York Times, Doe lawsuit. Team Ridicula is getting the most ridiculous. Furthermore, K. Fritz's declaration continues, Van Zandt stated that it will only provide information for each of the topics starting from, on, or about the filing date of the Doe lawsuit. Subject to that unreasonable limitation, Van Zandt stated that it would designate a Rule 30b-6 witness reasonably prepared to testify about non-privileged information response to these topics. Stated differently, even though the communications between Van Zandt and the Jones parties or their respective representatives concerning the contents of Jennifer Abel's electronic data seized by the Jones parties and subsequently delivered to Blake Lively through Van Zandt is highly relevant to Miss Abel's counterclaims against the Jones parties, and even though such communications surely occurred before the Van Zandt lawsuit was filed on September 27th. Oh my God, they did it again. 2024. It says 2025 here. Van Zandt has refused to designate a witness prepared to testify about the foregoing. Upon receiving the objections, the Wayfair parties agreed via email to narrow topic number 4 to Jennifer Abel's counterclaims in this actions and the defenses thereto. They're showing they're being very reasonable. And narrow topic number 5 to Blake Lively's allegation in paragraph 10 of her second amended complaint that she obtained the communications cited in her pleadings in connection with a lawful subpoena. Furthermore, and with respect to Van Zandt's relevancy-based objection, the Wayfarer parties reminded Van Zandt that in its order dated July 7, 2025, the court already determined that discovery from Van Zandt was relevant to Jennifer Abel's counterclaims against the Jones parties. Given that Van Zandt's deposition is scheduled for September 30th, 2025, merely a few days from now, the Wayfarer parties asked Van Zandt to withdraw its objections to the topics by noon Eastern today. Van Zandt has failed to do so. Okay, now I'm reading Van Zandt's opposition in full because it's important to read everything. But I'm not going to read it all, don't worry. But this part is worth sharing. Van Zandt says, consistent with the court's order and the agreement between non-party Van Zandt and defendant Abel, Van Zandt produced thousands of documents in July 2025 and completed its document production that month. Defendant Abel did not raise any issues with the production, identify any deficiencies, or file any motions relating to this production. Well, they did just say, as I shared with you moments ago, they're not asking for any more documents. This latest motion to compel is just about the upcoming deposition. They also included some email communications in this filing. God, it's crazy. These lawyers are getting so many emails sent to them on the daily about this saga. And they charge for reading every email, right? And I went back and I read in its entirety Van Zandt's objections, and they literally objected to everything. And they're really doubling down that Van Zandt is a non-party to this action and has no involvement in the underlying claims, defenses, or facts or circumstances related to this action. Lies. And doubling down that it's irrelevant. More lies. And I have no idea what the judge is going to do. It's Lyman we're talking about. Hi. But I'm glad we got this today, because all had been too quiet for my liking. I need this saga to keep sagaing. And I need you to check out my new merch collection. I have some inspired by Grab Your Friends, Wear Your Florals. And just this week, I launched Team Truth merch, as well as Team Perez. Check it all out at buypopstuff.com. That's buypopstuff.com. And I know that you like to stay informed and entertained. And you can get an exclusive podcast a week from me on our Patreon. Sign up today at patreon.com/P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N. Patreon.com/my name. And if I bring a smile to your face, I would love to do that in an even more special and intimate way. I make personalized videos for you or anyone for whatever the occasion. Book one right now at cameo.com/my name. P to the E to the R to the E to the Z to the H to the I to the L to the T to the O to the N. If you watched until the end, you're a superstar. Hit that like button. Don't forget. Share and leave a comment down below saying Madonna, or if you don't want to say Madonna, or in addition to Madonna, say your thoughts on this latest Van Zandt of it all drama in the saga. Let's discuss it all in the comments. Madonna, Van Zandt, what are they hiding? See you in the comments section.